Imagine this, you've been implicated in a criminal case, and during the investigation, the police seize a significant amount of cash from you. Days turn into weeks, and you start wondering, can I get my money back while the investigation is still going on? Today, we'll explore whether currency notes seized during an investigation can be returned to the accused. This is a pressing issue that often leaves people confused, and the answer isn't as straightforward as you might think. Stick around to find out how Indian law handles such situations, and more importantly, what you can do if your money has been seized. Let's first break down the essentials of this topic. Here are the key points we'll cover. First, seizure of currency. When can the authorities legally seize cash? 2. Ownership versus evidence. Can the money be returned if it's evidence? 3. Legal provisions for release. Under what law can you seek the release of seized money? 4. Recent case laws. What do the courts say about releasing currency? 5. Your rights. What to do if your rights are violated during the process. Now that we've set the stage, let's dive deeper into these points. In India, currency notes can be seized during an investigation if the authorities believe the money is related to a crime. This could be a bribe, proceeds from illegal activity, or even part of a larger scam. The seizure is generally done under Section 102 of the Code of Criminal Procedure or CrPC, which allows the police officers to seize any property that may be involved in an offence. However, the law makes it clear that this power isn't unlimited. The real challenge comes when the seized money is claimed to be evidence in the case. If the currency is vital to proving the offence, like money used in bribery case, courts are more reluctant to release it. In the landmark case of Sundarbhai Ambalal Desai versus State of Gujarat, the Supreme Court observed that seized property, including money, should be returned to its rightful owner if it's no longer required as evidence. The court further stated that the object of the seizure is not just to punish the owner, but to secure evidence for the trial. If you find yourself in this situation, Section 451 of the CrPC is your friend. This section empowers courts to pass orders for the interim custody of seized property, including currency, during the investigation or trial. You can file an application in the court for the release of your money, provided that it is not crucial evidence in the case. The court will evaluate whether the continued seizure of the currency is necessary. If it's not, you might be entitled to get it back. Now, let's look at some recent judgments. In Dhananjay Kumar versus State of Bihar, the Patna High Court allowed the release of seized currency to the accused, ruling that if the currency is not needed as evidence, holding on to it would amount to depriving someone of their rightful property. Similarly, the Bombay High Court in Bikram Singh versus State of Maharashtra ruled that prolonged detention of currency without valid reasons violates the fundamental rights of the accused. These judgments highlight a growing trend. Courts are more inclined to release seized property when it's not central to the case, emphasizing the importance of protecting an individual's right to the property. If your money has been seized and the authorities refuse to return it, despite it not being evidence, you have the options. First, file an application under Section 451 CrPC. This is the most straightforward route. You can request the court to release your money by proving it's not required for the investigation. 2. Challenge the seizure. If the seizure itself was unlawful or arbitrary, you can file a petition challenging the legality of the seizure under Article 226 of the Constitution through a writ petition in the High Court. 3. Appeal. If the lower court refuses to return the currency, you can file an appeal in a higher court. Don't forget, your right to the property is a constitutional right. Recently, there has been increased scrutiny of the powers given to investigation agencies concerning the seizure of assets, including currency. The Supreme Court has emphasized the need for a balanced approach. as highlighted in the 2022 case of Rajendra Kumar versus State of Maharashtra. The court ruled that prolonged seizure of property without just cause violates the rights to property under Article 300A of the Constitution. This indicates a shift towards ensuring that accused individuals aren't deprived of the money for unnecessary durations. So, can you get your money back? The answer depends on whether the money is critical evidence in your case. If not, the courts have shown a tendency to return seized money to its rightful owner. Here's a quick recap. First, currency can be seized during investigations under Section 102 CrPC. 2. If it's not vital evidence, courts can return it under Section 451 CrPC. 3. Landmark cases like Sundarbhai Ambalal Desai support the return of seized property when it's no longer needed. 4. Recent rulings like Rajendra Kumar emphasize protecting property rights. 5. If your rights are violated, you can seek legal remedies through the court. Remember, you have the right to challenge unjust seizure. Always stay informed about your legal rights. And if you find yourself in such a situation, make sure to take prompt action. If you found this video helpful, don't forget to like, share and subscribe to our channel for more legal insights. If you've got any questions or need clarification on seized property, leave a comment below and we'll get back to you. Take care and bye.